Hello friends, welcome to Pen and Paper YouTube channel. So today let's explore some key Supreme Court and High Court judgments related to check bounces as these are covered under section 138 of the Negotiable Instrument Act along with their authoritative citations for your reference. Friends, we will see the landmark judgment by the Supreme Court on Kusum Ingots and Alloys Limited versus Pennar Peterson Securities Limited. So this is from the year 2000. Friends, in Kusum Ingots versus Pennar Peterson, the Supreme Court held that even if a company becomes sick under SICA after issuing the check, the prosecution under Section 138 and can continue, and this preserves the law determined nature. So basically, Supreme Court mentioned that even after paying the check, the company becomes sick, they can't escape the liability. Friends, this is the second case we are going to discuss, that is Modi Cements Limited versus Kuchil Kumar Nandi from the year 1998. So friends, in this case, the stop payment instruction does not absolve the liability, and the Honorable Supreme Court ruled that stopping payment does not eliminate liability under Section 138. The liability, that is a legal liability, is still holds if the check is dishonored due to payment stop instruction. So this is a very popular and the landmark Supreme Court judgment. So where they mentioned that the mere stopping the payment is not going to absorb the liability, and hence the case continued. So friends, the next case we are going to discuss is the Rangappa versus Sri Mohan from the year 2010. So here presumption in favor of payee and the burden on drawer, and also the standard proof preponderance of probabilities is been discussed here. That is, uh, Supreme Court clarified that once a check is dishonored, a presumption exists that it was issued for the legal liability, and the burden of proof is going to shift on the drawer to rebut. That is, the standard is preponderance of probabilities. That is, the drawer need to prove that there was no legally enforceable liability existing, and hence the the section is favorable to the complainant. So friends, the next case we are going to discuss is the bonus mention MMTC Limited versus Medgel Chemicals and Pharma. So this is from the year 2002. So here confirms presumption applies even on stop payment dishonor. So the court confirmed that section 139's presumption of debt applies even if the check is dishonored due to stop payment. So if the drawer is going to the bank after paying the check and they are informing the bank to make the stop payment, then definitely the burden is going to shift on the drawer. They need to prove in the court that there was no legally enforceable debt present, and hence the court confirmed that mere making stop payment cannot make the drawer to escape from the liability. So friends, the next, the important landmark judgment which is coming from the High Court. So here Rajesh Agarwal versus State from Delhi High Court 2010. So the court emphasized summary trials, speedy disposal of the checks bounce cases. So the Supreme Court also mentioned, and Delhi Court in Rajesh Agarwal mentioned that the check bounce cases should be handled through summary trials to ensure quick justice. So this has been given from the High Court of Delhi. So friends, the conclusion for today's video is there are many landmark ruling with the judgments from the Honorable Supreme Court as well as many High Court that liability burden and procedure under Section 138 of Negotiable Instrument Act, and these landmark judgment shape how Section 138 is applied, identifying when liability attaches, what presumption arise, and how courts ensure the swift and speedy justice. And this was explained to you by the Pen and Paper channel. If you found this video useful, please like, share, and subscribe to our channel. Thank you.